Thanks, Rob. I've just made you host now.
Thank you very much for that, Alison. So thank you for joining us this evening. It's definitely not the most wonderful of days outside, so we'll just curl up inside and talk about some exciting legal issues. Firstly, I'll just get this up on the screen for everyone. So are the slides coming up on the screen for people? Okay. Hopefully that should be up now. Perfect. Okay, so this is just an introductory seminar about common legal issues and legal issues in the context of small business. What I'm going to be talking through today is very much general advice. So it's not intended to be legal advice. It comes with that standard disclaimer. If anything comes out of today that you might think, hang on, I need some professional advice, there's options available for you to source that advice online or elsewhere. In terms of questions for today's seminar, if you've got any queries, feel free to unmute yourself. Alternatively, I do have the chat channel up, so if you just type in a question, I should see that. Feel free to ask questions as we go or save them at the end. We should have a little bit of a time for a chat there. Okay, so we'll just be covering a few topics today. Firstly, a basic introduction to common business structures, so the kinds of business structures that are adopted within Australia. I'll drill into a bit more detail about companies and trusts because they're the more complex structures. You hear them the names being used quite regularly. People tend not to understand what they actually mean, what kind of business implications they have for setting up and operating a business. Separately from that, I'll be talking about the Australian consumer law. Structures are all about how you're managing your business internally. The Australian consumer law is an Australia-wide law that covers external relations, both with customers, with suppliers, and those kinds of other organisations. So it's worth being across that. And finally, given that people are good enough to come and listen to me for a bit, just a bit of feedback on how to get some value out of lawyers whenever you're dealing with them. I have some very firm views about how to get the most out of us, and you get to hear that for free. So moving right along, within Australia, there's 4 broad kinds of business structures that are adopted: the sole trader, the partnership, the company, and the trust. Now, 95% of all kinds of businesses that you are dealing with will be adopting one or more of these structures. So it's really important to be across what each of them mean, pros, cons. Starting from the simplest, sole trader. That is literally you setting up, getting the idea for your business name, registering your ABN, maybe buying whatever assets you need and getting started straight away. It's a very simple structure. It's very low setup cost. But what it means is that the business is in your sole name. So any risk, any issues arising out of that, they lie with you personally. So if you own a house, for example, and you're operating as a sole trader, that house is at risk, not just the assets you've got set aside for that business, your business bank accounts, business vehicles, those sorts of things. Slightly more complicated structure is the partnership. That's where we're getting 2 or more people involved in running a business. So the idea of a sole trader is it's one person going out and trading a business. The partnership is the most simple structure to get multiple people involved in a business. Same kind of approach. The income's apportioned between the partners. But the main issue with the partnership structure is that each partner is liable for 100% of the partnership debt. They can try and sort it out internally amongst themselves, but if one partner incurs a liability, all partners are considered to have incurred a liability. So what that means is that it works well if there's a very small number of partners, or you trust the partners implicitly. So partnerships tend to work for family arrangements or farming arrangements. They're pretty common. But once you start getting into more complicated business arrangements, the partnership doesn't really work very well, because the more people you have involved, the more points of value you have. And again, every partner being liable for a partnership debt, the risk adds up very quickly. Third kind of structure is the most common structure you see out there. It's the company setup. And the idea of a company is it creates a separate legal entity, a separate legal person, separate from yourself, and that's what runs the business. That entity is same kind of approach for whether it's Telstra or a small local business. There is a company that operates the business. It is operated by directors. It has shareholders that it runs the business for the benefit for. And the idea of the company is that the shareholders, the people who are investing in the business, they have what's called limited liability. So the idea of a company structure is that if something goes wrong, if there is a debt or liability or claim against the business, it's the company that takes the hit. And if the assets of the company are not enough to pay those debts, the company goes into liquidation, it fails, but the shareholders, the people actually running, who have set up the business, are protected. Their personal property, their assets are not at risk. Now, what that means practically is that there's going to be directors overseeing all of that, and they've got some various obligations that I'll talk about later. But that idea of limited liability is critical, and it's the reason why the company structure is such a common format. Because once you start incurring substantial debts, you're buying property, those kinds of things, you want to try and protect it. And that's why companies are often a very popular first business structure. The final structure out there is the trust. And that doesn't create any separate legal entity. All it says is that someone is going to operate a trust. Lots of different kinds of trusts out there. A trust that is described under a trust deed. And the trust deed is a document that says, here are all the rules for the XYZ trust. It sets out the powers of the people involved, the roles, how it's going to be managed in quite extensive detail. Those kinds of documents tend to be 30, 40 pages. Put bluntly, the reason people like trusts is they're often a good way to manage tax, because the way what can be done with trusts is you can play around with who's benefiting from what part of the business, and the trust moves income back and forth each year in such a way as to maximise the tax outcome. Now, those are the four brief summaries of the four kinds of business structures that are available. They're all building blocks though. What that means is that you can have, for example, a company that is acting as trustee for a trust. It's an added degree of complexity, but there might be some structural reasons for doing that. There might be a tax reason for doing that. Alternatively, you can have two companies working in partnership, or a individual sole trader working in partnership with a company. They're just the building blocks of how you would build structures, but once you drill down into the details, most businesses will be combinations of one or more of these structures. Now, I'll drill down a little bit more into the company structure next. Just before I move on, any questions at this point? No, that's all right. So in relation to the company, there's a couple of, I've talked a little bit about limited liability, the idea that the company is solely liable for the debts of the business. But within the company, there's going to be a couple of key roles, directors and shareholders. The directors are the people who are actually operating the company on a day-to-day basis. Often employees, they're often the founders, at least initially, but they don't have to be. They may not even be employees of the business, but their role is to make the day-to-day decision, the larger decisions about the business, depending on, and there can be one director, there can be many directors. But the idea is that periodically the directors will sit down, meet, either formally around a table or just by signing off on the paperwork, and make the key decisions about the business. Separately from that though are the shareholders. Shareholders' role starts by them putting an initial amount of money into the company. It can be a small amount, $1, $2, $3, or it can be a substantial amount where they're putting the money into the company to buy shares. Now, the difference between the director and the shareholder is the directors are responsible for the day-to-day management, as I've said, but separately, the shareholders have an oversight role. Depending on the size of the company, complexity of the company, the shareholders have the right, are entitled to perhaps annual general meetings, just going through and reviewing the company's finances. The shareholders have the right to hire and fire directors. So at the end of the day, the directors of the company are accountable to the shareholders to make sure that the company is operated properly. If the directors if the directors are incompetent, don't manage the company properly, then they are potentially responsible to the company and to the shareholders for any kinds of debts. So the reason I'm talking at a very high level here is that the directors are the ones with the day-to-day responsibility, and they're the ones with the skin in the game. They're accountable to the shareholders. Shareholders often have a bit more of a passive role, being involved from time to time, taking a look at the company finances, but they don't need to be there on a day-to-day basis. So what that means for you, people starting up businesses for the first times, they should actually turn their mind to who should be a director, or who should I have as directors, and who should my shareholders be? And it's not necessarily the same person. So, for example, in the classic husband-wife situation where someone's going out and starting a business, it is often worthwhile just saying only one of those people is going to be a director because they're the person with the skin in the game. Whereas the other person is the shareholder, is accountable, is able to receive the profits from the business. And it's often a good way to just apportion the risk and the liability. So the director, the person who's taking on the risk of managing the business, they may not actually own any property, may not own any assets, and it's the other partner who actually owns the shares, owns the family home, all those kinds of things. And the reason for that is directors are the ones who are responsible for making sure taxes are paid, superannuation is paid, all those kinds of expenses. How does that happen? Put quite simply, because the limited liability rule can be exploited, you set up a company, you incur lots of debts, and then just walk away. The law requires that directors are responsible for making sure those debts are paid as and when they fall due. And because the government rigs the rules in favour of itself, making sure taxes and those kinds of debts are paid as and when they fall due. So what that means is the director has personal incentive for making sure that all those liabilities are paid. And that's why they're the ones who are at risk. Moving aside from the differing roles of directors and shareholders is actually how you set up the company, how you're funding it. And that's where we're talking a little bit about share structures, because you can do various things about how your shares are organised. For example, most companies have what are called ordinary shares. You buy a share for $1, it's worth one vote, it's worth one share once profit is available to be distributed out of the company. But that's not the only way of organising shares. You can have more complicated models about shares, for example, a share that has more votes associated with it, or you can have shares that get a higher amount of the profit when the company is paying money out. Those kinds of complex share structures, they don't really make sense when it's just one person setting up a business. But they give extra tools if you're wanting to get investors in, if you're wanting to build your business, because playing with the share rights does mean that you've got a few extra tools to work with in dealing with a new business, in dealing with investors, or dealing with business partners to say that I'm contributing a certain amount of money up front. So these are the kinds of shares that I'm going to get, for example. Now, the issue with companies and shares is once you've got a shareholder in, once you've got multiple shareholders in, I should say, those shares are their property, just like a house or a car or anything like that. The question is, what happens if that person walks out the door? And this is a common failure mode for companies. You start up a business, you start up a company, and you each issue each other shares in the business. And then your co-founder walks out the door and leaves. goes on a holiday, lost interest, they're not that interested in the business. What happens then? Unfortunately, in those kinds of startups, if you're only owning 50% of the shares or so, you don't really have much incentive to continue developing or to continue growing the business. So what that means is when you're actually issuing shares, consider, do we actually need to issue shares to this person? What kind of security do I have to make sure that they stay in the business, that they're not just going to walk out the door and leave me continue insisting on being involved, at least getting a share of the profit. That leads me to the next issue about how do you fund a business? Because I've talked a little bit about shares, and you issue a share, the person buys a share in exchange for money and puts that money into the company. That's the equity funding model for starting up a company. But there is a separate model of funding company called debt. And that is quite simply where instead of you buying shares in the business and being the classic investor, the company borrows from you, borrows an amount of money, and you're effectively acting as the bank for the company. Now, the reason I flag the difference between those two models is when you're putting money into the company by way of debt, you're not buying a share in it. You've got a right to repayment, you might have a loan agreement, you might have documentation saying that this is when I'm going to be paid back. And that's very prudent when you've got other shareholders involved, so everyone's clear about how money's going to be handled in the business. But if you're funding the business like that, you're not actually buying a share in the business. That's what the equity model's about. So what that means is when you're setting up your business, when you're starting to put money in, you should have a very clear idea in your head, am I wanting to issue shares in my company? In which case there's again, you're issuing property rights in the company, you're issuing shares that people can buy and sell and deal with. Or are you putting money in that you're wanting as the bank, that you're wanting to be paid back at some point? Making sure, again, when you're dealing with only one person, it's just you setting up the business, generally not that important unless the company fails. But if you've got multiple people involved in a business, being very clear where the money's going in to buy shares or where the money's going in as a debt, and if so, the terms of repayment, clarity there is critical. Because in my experience, the most common reason for companies to fail is because shareholders disagree, directors disagree, no one has a clear set of expectations. So when you're getting people involved in these kinds of businesses, when you're setting up a company with other shareholders, you should always have a very blunt discussion from day one. How are we going to manage the business? What are our expectations? How are we going to resolve disputes? If this is sounding like almost a relationship agreement or divorce or family law or those kinds of things, it's because it is. Because again, in most instances where these kinds of internal disputes happen, it's because there's been a small issue, people haven't had common expectations, there's been basic disagreements, and from that point on, people aren't trusting each other and it just snowballs. So in terms of managing the corporate structure, be aware of the fact that it is a separate legal entity. It's not your money, it's the company's money, and keep that in mind. Be aware of different kinds of roles and powers of directors versus shareholders, because that can also be quite important. Think about what kind of share structure you're dealing with, what works for you. Are you wanting a share structure that is more appropriate for getting investors in, or if you're just using the shares just because you need one or two shares to run a company? And finally, when you're putting money into the business, into the company, make sure you've got a very clear picture on whether it's going in exchange for shares, and if so, the appropriate paperwork's done, or if it's going in for debt, in which case, again, what kind of security do you want to make? How do you want to make sure you get paid back your loans? Just for those people who have been clicking in, just feel free to sing out if you've got any questions or queries. I do have a little bit of time at the end, so alternatively, you're quite welcome to raise questions at the end. Okay, so the second of the four of the two complicated structures we're talking about is the trust. Now, as I was saying, the trust structure doesn't create a separate legal entity. All it says is that there is a trust document, a trust deed, that sets up the rules for the trust you're operating. Now, there is a reason I'm being so vague there. There are many, many different kinds of trusts, all different. There's some common themes, but each trust is unique and is dealt with separately. So managing the trust, you'll see the critical thing to remember is there will be a trust deed. If there is a trust that is being set up for running a business, there will be a trust deed. I'm repeating that because that point is critical. The second point is please do not lose that trust deed. Trying to replace a lost trust deed is painful and can often involve going to the Supreme Court and is a waste of money. So what I'd be...
Getting tired now.
Yeah, pretty tired as well.
Yeah.
Okay, so my very frank advice, please do not lose the trust deed. Make sure it's in a safe location. It might be a document you look at once in 10 years, or the accountants or the lawyers or bankers ask you about it occasionally, but please do not lose it, because that says what you can and can't do. And because the trust is not a separate legal person, it's not a company, it's not a person, it's nothing of the sort. Without that trust deed, it becomes very problematic to operate a trust because you have no rules, you have no process on how the trust is to be administered. But where do you get those trust deeds? Often you just buy them online. There's a lot of suppliers online who will say, we have a pre-written trust deed in common categories. You order the appropriate trust deed that is appropriate for the kind of structure you're set up. And the common trust structures is often what's called a fixed trust, discretionary trust, unit trust. They're the three main categories. But as I said, there's many, many different kinds of trusts. Almost everyone in Australia is a member of a trust by way of their superannuation, because the superannuation is, again, a trust that's with money held on trust for you. And depending on which super fund you're with, you can go online and track down the original trust deed that is administering your superannuation, for example. And they have that kept very secure because, again, they don't want to have to try and deal with the hassle of tracking down the trust deed. But what are the major kinds of trusts that we're talking about? Fixed trust is a relatively straightforward document. All it says is that a person, a trustee, is administering the trust on behalf of one person or a specified list of people. And the idea is that there is literally a list of between one and however many people, identifying who is entitled to share in the benefits of the trust. And that list is locked in, it's fixed. A discretionary trust is a little bit more convoluted. What it says is, what the discretionary trust model is all about is primarily a list of beneficiaries, but intended to be very broad. So for example, it might say that you and your partner are the primary beneficiaries, and then there's multiple other beneficiaries, other people who can benefit from the trust, who are defined by reference to you. So that can be your children, your grandchildren, their spouses, your cousins, your brothers and siblings. It's generally drafted very broadly, trying to cover as many individuals as possible without going for pages and pages. And the reason for that is that at no one time does a person benefit from that trust until the end of the financial year. And the idea of that is that at the end of the financial year, trustees take a look at the trust, see how much money has been made, and decide who's going to benefit from it at that point. Sounds a bit convoluted, but the reason for that is tax, quite frankly. At the end of the year, the accountants go through and work out who's going to how do we minimise tax across a family group. There might be some children who've just left high school and at university and need to be paid, or need fees to be paid. So they suddenly get a distribution out of the trust. The discretionary trust pays them an amount of money. But that changes from year to year based on tax and other financial advantages. And the final kind of common model is the unit trust. What that is the trust, it's very similar to a company structure. A trust issues units, which just happen to be very similar to shares. And it's whoever owns those units at any point in time is entitled to payments out of the trust. The reason unit trusts are often used is they step away from the corporate model and they're very private, because the companies, for example, for small companies, you can do a very simple search online and find out who owns what shares in a company. For unit trusts, but again, those documents are kept privately. So if you want to have a number of investors, a number of people involved in a business, but they don't want the records to be publicly accessible to whoever wants to search online, unit trust is often a good way of doing that. I've probably gotten the order a little bit wrong here, but just there's a number of common roles in the context of a trust. There's the trustee. There's the person, that's the person who administers the trust, who owns the business, operates the business, deals with the money and ultimately pays the money out. And who do they pay the money out to? The beneficiaries or the unit holders. So beneficiaries are the ones generally applies to a fixed trust or a discretionary trust. They're the people who are just ultimately entitled to benefit in various proportions. The unit holder, they're the people who are entitled to benefit in the context of a unit trust. So between the beneficiaries and unit holders, they're the people that the trustees are working for at the end of the day. Finally, a lot of trustees have a bit of a weird role. They call different things appointors or guardians or principals. There's different names for them. What they are, though, is the person who's got almost a veto right over the trust. Because I've been talking about a trustee having very wide powers under their trustee to do things, a lot of trustees will say, before certain steps can be done, the appointer needs to be appointed or consulted, or the guardian needs to be consulted. Again, there's no one-size-fits-all approach with trusts. It depends on what kind of what document you've ordered and what the document actually says. What that means for people operating trusts, though, is if you do go to a trust model, that's where you've definitely got an accountant helping you manage the system. You've got some professional advice helping you manage it. And if you are doing any more complicated transactions, more difficult transactions, that's where you're going to probably be consulting professional advice. Now, I've summarised the 4 options. So, million-dollar question, which one is the right one for you? Unfortunately, there is no one-size-fits-all approach. What there is, though, is there's a number of factors you should keep in mind. So firstly, industry requirements. Some industry requirements really push you towards one model, for example. Best example off the cuff is liquor licensing. In Victoria, liquor licensing generally requires a lot of disclosure about who's involved in the business. So if you're going for a discretionary trust model with lots of people involved, that becomes messy very quickly. If you're wanting to have business partners involved, that's going to inform what kind of model you're thinking of. Obviously, a sole trader doesn't work at that point, so you're needing a business structure that enables them to be brought in and to have some sort of share and involvement in the business. On the other hand, if it's just yourself, you're probably going to be driven more by managing risk. You might be wanting a company structure, or if you're concerned about risk in your personal name, or if you think your business is low risk, you might say, fine, I'll just leave it in my own name and opt for a sole trader structure. Tax, that's the kind of, that's always a major variable, because all these different structures, I've talked about the legal side of things, but they each have different tax outcomes. So you might be driven to say, this is going to be a really profitable business for me, or I'm wanting to make sure I make a go of it. And even when I sell the business, I want to get the most out of it. That might dictate which structure you're picking. If you're wanting to get investors involved, you're going to want a structure that allows them to come in. So again, discretionary trust models are probably not right. You're probably looking at a unit trust model or a company where you can issue units or shares to get investors in. And finally, there's the finance side of things. The more complicated the trust model, the more the structure, more overheads you're going to pay in accounting and those sorts of fees, the more upfront costs you're going to pay. Is that justified against the other costs you're going to incur? One other thing that's also very worth being alive to is, are you looking for grants or other other funding from government or councils or other organisations? If so, you probably should take a look at what their requirements, because they will impose requirements and say, we will fund these kinds of businesses or these kinds of business structures, but we won't fund those. So if that's going to be a critical part of your business setup, that's something for you to keep in mind. So when picking the right structure, what you're going to be doing is selecting from these kinds of factors and weighting them and ultimately coming with a solution that's at least the best model for you at that point in time. As I've said, there's no right model, so I've probably lied a little bit in the heading, but it is the best model. It's my recommendation on how you go about it, how you make that choice. Keep in mind all the factors, think about which ones are important for you and go from there. Now, I've talked a lot about how you're setting up the company internally, setting up the business internally, but again, you're going to be going out into public and Australian life and dealing with suppliers and customers and the like. And in doing that, you should be alive to what's called the Australian Consumer Law. It's an Australia-wide set of laws. It's the same in Victoria and New South Wales and Tasmania. That is a baseline set of requirements for trade and commerce. Now, I'm not going to even try and cover the entire law today. It's just not going to happen, but I'm going to touch on a few key points. First thing to be aware of is it has a very basic requirement, a very basic ban on misleading and deceptive conduct. And literally, I've just copy-pasted the law there. A person must not in trade or commerce engage in conduct that is misleading or deceptive or likely to mislead or deceive. That is literally the law there. You would probably appreciate that covers a very wide set of transactions. So for example, issues about debt collection, people putting up signs banning refunds. This is the law that Belle Gibson was prosecuted over, that she was sued over by the ACCC, which is the organisation that manages the Australian Consumer Law Australia-wide. What that means though for yourselves is, if you're going into trade, you should at least be vaguely aware of the Australian Consumer Law and some of the key issues it raises. Both it gives you rights and it gives you obligations. I'm going to focus on a couple of key areas. Firstly, consumer guarantees and then unfair contracting terms. But the Australian Consumer Law covers a wide scope of areas such as product guarantees, product safety, recalls, those kinds of things. So just going into consumer law, firstly, what is a consumer guarantee? That a consumer guarantee covers all goods and services up to $40,000. So if you are buying something, even if it's got nothing to do with home use or anything like that, for $39,000, it's a consumer purchase. Even if it's for the office, even if it's for your business. It covers all personal, domestic or household goods over $40,000, up to any amount. So if you're buying and selling land, it applies. If you're buying a very nice car, it applies. What that means for you is when you're trading and you're thinking, okay, so I'm selling goods and you're buying goods in your business that's under $40,000, you have the benefit of the automatic consumer guarantees. Conversely, if you're making a very substantial purchase in your business, if you're buying very big, new, expensive equipment that's over $40,000, you don't automatically have the benefit of these guarantees. And at that point, you might be taking a closer look at contracts and paperwork to say, what kind of warranties, what kind of protections do I have? But once you actually get over the first hurdle and it's a consumer, it's within the scope of consumer guarantees, You have a number of base requirements depending on whether it's a good you're buying or whether it's a service. In relation to goods, I've listed the key ones there, but there's a number of other requirements. The critical ones though are the good is to be of acceptable quality. So if you're paying a small amount for a small basic goods like paper clips and those kinds of things, quality is not going to be a huge issue. But if you're spending $10,000 on a new computer, very good computer, then obviously the requirement for acceptable quality goes up quite substantially. It needs to be fit for any disclosed purposes. So if someone comes to you and says, I'm buying I would like you to sell me some goods for a specific purpose, you're under an obligation, if the consumer law applies, to make sure it's fit for that purpose. Again, if you're selling by way of description or samples, you're required to make sure the product matches. And there's a general requirement that if you're selling goods or, that require repairs or spare parts, there's some availability for it. So you can't just say, no, we don't repair spare parts, that's not our problem. On the flip side, for services, it's a shorter list. Services are required to be provided with due skill and care, fit for the disclosed purpose, and within a reasonable time. Often it's the latter one that people have arguments about. How long do people have to deliver services? But those are the base obligations that if you're paying less than $40,000 for a service, which is pretty common when you're starting out, you've got the benefit of those kinds of protections. Which leads to the very obvious question, what happens if a guarantee is breached? And I'll be honest, it depends. It depends on whether it's a major failure or a minor failure. It depends on a case-by-case basis, but the general thrust is that it's a major failure if you would never have actually purchased the good or service as a result of that failure. So for example, if you're buying a TV and the TV literally does not work. Contrast that with if you're buying a TV and there's some chips or some scratches, those kinds of things, that's more inclined to be a minor failure. The TV still fundamentally works, it's just you haven't really gotten the full value for the product. And the reason for the distinction for that is, the distinction between the two is if it's a major failure, then the consumer, the purchaser, is the one who gets to decide whether they're getting a refund or a repair or compensation. Alternatively, if it's a minor failure, it's the vendor, it's the business's choice on what kind of resolution is being reached, whether there's going to be a repair, replacement or refund. Now, the one thing to remember is that if you are selling goods that you buy, selling goods you bought wholesale, you're still the person who sold it to the customer, which means you're the person on the hook if the goods don't comply with the ACL. Now, you do have a right to claim against your supplier, but if the goods have been shipped from overseas or something like that, you might have problems collecting. So that should be factored into when you're selling the goods, just making sure that you manage that risk properly. And how do we manage that risk? Well, a few things. Firstly, training staff, making sure your marketing's on point, because the easiest way to breach the ACL is to make statements that are false and misleading, which triggers all these sorts of issues. You can also, depending on how you're doing your sales, you might include warranties or disclaimers or contracts saying, this is the scope of the guarantee, this is the scope of the warranty. Now, you need to be a bit careful there because you can't contract out of any of these kinds of consumer law guarantees. It'd be too easy for lawyers if you did that. What you can do is you can include language capping liability, saying if we breach for any reason, the worst we have to do, the worst we're out of pocket is we'll reimburse you the sale cost or those things like that. Again, that's the kind of language that's worth being across, both when you're the vendor, when you're running your business, but also when you're buying goods yourself. Because again, a lot of the goods that you'll be purchasing in early stages of your business will be under the $40,000 cap. So being aware of what are your rights if the supplier doesn't meet their ACL obligations is also quite relevant. Now, moving right along, final section in relation to the ACL that I'll just be briefly covering is unfair contract terms. Now, the idea that the unfair contract term provisions are, everyone's seen them, they're standard form. You go to a business, You ask for some services or goods and they give you 30 pages worth of standard form language that you look at and your eyes glaze over. Now, you can enter into that contract. It's a binding contract. The terms have been made clear up front. But what this, the unfair contract terms laws mean are that if there are terms that are considered unfair, and it's a standard form contract, so the contract that's just put to you, where you don't really have the option to bargain or negotiate, you do have certain kinds of terms are considered unfair and they're banned. Now, these kinds of contracts, they relate to small, they'll relate to transactions up to $300,000, or if the transaction's intended to be over more than 12 months, up to $1 million. What that means, the idea is that once you start getting over those amounts, people are expected to be able to look after themselves. So the idea is that they're targeted. This protection is available for small businesses when you've got less than 20 staff and when the sale prices are relatively low. But just because a contract's just put to you as take it or leave it deal does not mean that the terms are automatically unfair. It's a question on whether it's significantly altering a party's rights or it's not reasonably necessary to protect their interests. And that needs to be distinguished from the core terms of the contract. What's the price of the good? What goods are being supplied? Or the kinds of terms that have to be included by law, for example, under a franchising arrangement or under to sell land, those kinds of things. Common themes, though, in terms that are considered to be unfair are where one side can just change the price or not have to actually carry out their part of the bargain, or if they're being charged absurd penalties just because they're unable, just because a minor breach in the contract occurs. So often when this tends to crop up for equipment finance arrangements, when you're purchasing, often for kitchens, there's certain suppliers, they've got multiple, many pages worth of contract, and they'll just throw in their terms that require that if there's a minor breach, you pay every penalty under the sun, or an absurd penalty. Those kinds of clauses can be considered to be unfair. So if a dispute ever arises, this is at least something you might give you something to push back on. Now, if a term's considered unfair, there are a few potential outcomes. Court might just put a line through those clauses and say we won't enforce them. There might be orders for compensation or injunctions preventing a person from relying on those contracts or on those clauses. But what it doesn't mean, though, is that you can avoid the contract entirely. All they're going to do is just readjust the bargain somewhat so that it is no longer unfair. Now, we've blitzed through a number of different topics, but what I might talk briefly is just some very basic recommendations when using lawyers. Firstly, we have, dealing with us, can be quite intimidating. I try to minimize that, but at the end of the day, all we're doing is trying to advise and protect you in relation to your rights. The reason I say that is that you should be the one calling the shots. We should be telling you what the legal outcomes are, what the options are, what your rights, what the requirements are. But we have a job to give you the information you need to make the call, and then you tell us what to do. It's really easy for us to get into the other way around, to just tell you what you should and shouldn't be doing. But at the end of the day, it's your lives, it's your businesses. You're the ones who should be making the call. In terms of legal advice and being clear about your needs, please tell us what outcomes you're looking for. Makes life a lot easier for us if you say, this is what I'm concerned about. This is what I should be wanting. This is what I'm wanting. But also take on board that we've got, we tend to have a lot of experience in these kinds of areas. We might say, okay, so you're concerned about this issue, where you're concerned about risk. You might want to take a different path to resolving that issue. So if you can be upfront with your needs, we're going to be in a better position to be able to make recommendations or give suggestions. Costing. It's the very classic hard conversation that people have with lawyers. It's all over the place because it's a professional services industry. So what one person will want for doing a job will often be very different from someone else. So be quite willing to shop around. For more complicated jobs, it's often very hard to cost up front. For straightforward, just basic production of document jobs, it should be a relatively straightforward task. Again, be upfront, be communicative. In all Australian states, there are obligations on lawyers to give estimates or give advice about what kind of costs are going to be charged. In Victoria, if there's a cost going to be charged over $750, we have to give a disclosure. Failure to do that is professional misconduct. Anything over $3,000, it's going to be a more comprehensive disclosure. So if you're not being given those kinds of upfront warnings, that's probably a sign about how well organised that solicitor is. Finally, when dealing with a lawyer, be honest, be upfront. Again, tell us what you need, tell us what happened. Discussions with the lawyer are confidential for a reason, and as long as you're upfront with us, it's a lot easier for us to do our job properly for you. A lot of people come to see us because something's gone very badly wrong, or something's a bit weird, or they're embarrassed. Please tell us, we've probably seen worse. The worst waste of times I see from a perspective for clients is because someone's tried to conceal the truth or hide the truth, and it doesn't end well, it doesn't end cheaply, and at the end of the day, the lawyer's probably not going to care because they'll just say, well, clients lied to me, I don't really care. And we all have clients do that. It's just a fact of the industry. So before we wrap up, are there any questions, queries, comments? I think everyone's feeling a little bit stunned after all of that information.
It's a very informative session. Thanks, Rob.
It's a very dense discussion, so I do appreciate everyone's patience, and hopefully people have found that of some benefit. So in that case, you might just call it a day and close this case.
Well, thanks again, Rob. That was great, and as I said, very informative. So we appreciate you spending this evening with us and presenting as part of our Let's Talk Business webinar series. For everyone who's joined us this evening, as you're aware, this is part of a series which Council is putting on. Our upcoming topics include a session by Lifeline, Strong Minds in Difficult Times. We have the one next on the 17th of September, which is when things don't go as planned, and it's support for businesses managing redundancies. We also have one coming up after that on cybersecurity. There is another group which we work with, which is ASBAS, and we are running a session with them on the 30th of September, which is how to sell products on Facebook. So if any of those are of interest to you, please reach out to me. Otherwise, have a look at our Eventbrite page to organise your registrations. So thanks again, and have a lovely evening.